When we began our discussion of federalism at the start of the semester, we suggested that federalism concerns the vertical relationship between the federal government and the states, as well as horizontal relationships among the states, while the separation of powers concerns the horizontal relationships among the three branches of the federal government. Recall that the three branches of the federal government are the legislative, established in Article 1 of the Constitution, the executive, established in Article 2, and the judicial, established in Article 3. We've already examined some aspects of the judicial and legislative powers in the context of our federalism discussions, and we also looked at some separation of powers aspects of the judicial power in our discussion of judicial review, advisory opinion, standing, ripeness, mootness, and the political question doctrine. Now we'll examine the executive power. Whatever you think of President Trump, there's no denying that his presidency has fueled enormous public debate about the role of the executive and the scope of executive powers. In some ways, we might view President Trump as simply a new level or phase in contemporary debates about executive power that have been raging since the 9/11 attacks. Questions about executive power reached the Supreme Court several times as a result of the definition of alleged enemy combatants after 9/11 under President George W. Bush, as we'll see in Unit 8. And during President Barack Obama's 2 terms, conservatives complained that executive power expanded dangerously through the use of executive orders when the legislative process stalled and through the questionable regulatory moves by administrative agencies. Of course, although debates about executive power have been fraught in recent years, they're nothing new, particularly in times of war, crisis, or transition. Some of the key early precedents we'll examine arose in the context of the Civil War and involved dramatic actions taken by one of our most revered presidents, Abraham Lincoln. Americans care about executive power because of our history and because of the lessons of history generally. The Declaration of Independence is an extended complaint against the claimed abuses of power by England's King George III. If there's any general principle most Americans of any political stripe have agreed on throughout our history, it's that our executive is an elective president, a fellow citizen accountable to the other branches of the government and to the people, and subject like everyone else to the rule of law, not a king. Of course, our agreement on this general principle has not prevented us from investing the office of the presidency with a sometimes mystical aura, invoking at times the pomp and imagery of kings and empires. Consider, for example, these images of George Washington, imagining him as a classical Roman ruler, or these images of the American eagle, drawn straight from the heraldic imagery of the Roman legion. But whatever need we have for an office imbued with these images of unity and authority, we expect that our law finally constrains the executive's power. So what exactly does Article 2 of the Constitution say about the executive's powers? As we read Article 2, we're immediately confronted with an interpretive problem. Article 2, Section 1, called the Vesting Clause, states that the executive power shall be vested in a President of the United States of America. Article 2, Section 2 and 3 then enumerate powers of the President. The interpretive question is whether the Vesting Clause confers general inherent executive powers that are then further illustrated but not limited by the enumerated powers in Sections 2 and 3, or whether Sections 2 and 3 are the exclusive list of executive powers referred to in Section 1. The Supreme Court has never given a single clear answer to this question. The enumerated powers in Section 2 and 3 of Article 2 are relatively limited, which is one reason some people argue that the Vesting Clause must represent a broader grant of inherent powers. Section 2 states that the President is Commander-in-Chief of the Army, Navy, and Militia when called into the actual service of the United States, may require opinions from executive department officers, may issue reprieves and pardons except in cases of impeachment, negotiates treaties with consent of 2/3 of the Senate, makes appointments with advice and consent of the Senate, and may make recess appointments. Section 3 states that the President shall from time to time give State of the Union addresses to Congress, may convene both houses on extraordinary occasions, may receive ambassadors and other public ministers, the Reception Clause, shall take care that the laws be faithfully executed, and may commission all U.S. officers. Section 4 of Article 2 states that the President may be impeached for treason, bribery, or other high crimes and misdemeanors. Many of these enumerated powers and the impeachment clause raise their own interpretive issues, some of which we'll come back to later.